If you watched our EU AI Act overview, you know the risk tiers and the August 2026 deadline. This deep dive is for product teams who need role-specific obligations, provider versus deployer, Annex III mapping, GPAI rules, conformity assessment, and what happens after launch. The same product can wear different legal hats. A provider develops AI or places it on the EU market. Providers own the risk management system, technical documentation, conformity assessment, CE marking, instructions for deployers, and EU database registration. A deployer uses AI under their own authority, integrating a vendor model into hiring, credit, or public services. Deployers must follow provider instructions, assign human oversight, monitor operation, retain logs, and in many public sector high-risk cases, complete a fundamental rights impact assessment before use. Why go deeper than headlines? Procurement teams and notified bodies do not ask whether you have heard of the EU AI Act. They ask which Annex III category applies, who signed the FRIA, and where your post-market monitoring plan lives. Overview knowledge tells you high risk exists. Deep dive readiness means a RACI per system, backlog items tied to articles, and incident playbooks your on-call team can execute. Annex III is where most product scope lands. Categories include biometrics, critical infrastructure, education and vocational training, employment and worker management, essential private and public services like credit and insurance, law enforcement, migration and border control, and administration of justice. Product action. Map each feature to a category and subcategory, document the rationale, and link it to your risk register. If you cannot explain the mapping, you are not ready for conformity review. General-purpose AI models face separate obligations effective August 2025. All GPAI providers need technical documentation, information for downstream integrators, and a copyright compliance policy. Models with systemic risk, very capable frontier models, ad evaluation, adversarial testing, serious incident reporting, and cybersecurity measures. If your product embeds GPT-class models or ships your own foundation model, GPAI rules apply even when your application is not Annex III high risk. Conformity is the gate before market placement. High-risk providers maintain a quality management system, compile a technical file, and undergo conformity assessment, internal for some categories, notified body for others. Successful assessment yields CE marking and registration in the EU database. Deployers in public sector high-risk scenarios conduct an FRIA, publish a summary or register it, and operate only with appropriate human oversight. Post-market monitoring is not optional. Track performance against intended purpose, report serious incidents within 15 days of awareness, and implement corrective action when systems drift or fail. Enforcement carries real weight. Prohibited AI practices can draw fines up to 35 million euros or 7% of global turnover. Other breaches tier lower, but reputational damage and market access loss often hurt more than the fine. Monitor, detect incidents, report, and correct. That loop must be operational, not a legal memo in a folder. Your next steps: build provider and deployer RACI for every AI system in your inventory. Map Annex III and GPAI obligations to engineering backlog and wire evaluation, plus FRIA templates before August 2026. AiVELabs offers article-mapped learning paths. AiQualtest helps you run governed evaluations and export audit-ready evidence. Visit aiqualtest.com and learn.aiqualtest.com. Thanks for watching. Subscribe for weekly AI governance and evaluation content.